I have something.
We provided a rather voluminous response with an
One moment,
attached exhibit, Judge.
Ms. Pickard, I can hardly hear you. You're breaking up a little bit, but I do have the file now. So give me just one moment here. I see that on the 3rd of October 22, the court entered the judgment by default for $4,863.92. I do note that prior to that time, the file reflects that there was a defendant's response to plaintiff's complaint in four paragraphs, if you will. And the defendant indicates that the Illinois Attorney General Office led a coalition and opening an investigation regarding subprime lending, et cetera. The plaintiff claim is related to an auto loan. Stanford forgave the balance of the loan in 2020, paid $950 of the final restitution to the defendant. And then point 3, plaintiff claim is therefore unfounded, et cetera. All right, and
so, Your Honor, we addressed that in some detail in our response. So, I don't know, if it's pleasing to the court, we could maybe fax over our response to you.
I do have the response now, counsel. I didn't have the file. Just give me one moment here, please.
Okay.
All right, I have read the response, and of course I've read the motion, and I've also taken a look at the underlying issues raised as it relates to this debt collection. It does appear that there is an admission that there was indeed a debt. It appears that the defendant claims in this situation that the debt was forgiven. Let me start there. This is the IK, if I pronounce it correctly. Do you have any document from Sandifer indicating that they have forgiven your any deficiency in indebtedness regarding this matter?
Your Honor, as far as documents, I do not have any, because when this matter was in effect, what had happened was on their website on Santander, it stated that consumers that had got a loan from them, it was being forgiven, and that would reflect on within their credit report. And that's how they'd be able to identify if their loan was within that sue, because they were being sued for just a little bit of the details, a little bit of around 500.
Give me too many detail. They were being sued for some debt practices that were not allowed by law. And so subsequent to that, there was some agreement that was reached. But my particular concern has to do with whether or not you received a letter of, essentially a letter of discharging of debt where they've forgiven it, because without that, you don't have anything to establish that you were forgiven of this debt. That's the problem. Go ahead. I'm listening to you, sir.
I do understand that, Your Honor, and there was in fact a letter sent, although it's not in my possession anymore, and I lost it due to the fact of it. It's been years, because this has been something since 2018 or so, I believe. And when that letter was sent, it was around, if not 1 year ago or 2 years ago. So I do not have it in my possession. But what I did have was what reflected within my credit report and showed that that account was closed. And also the information that was relayed to me within their website. But as far as a document, no, I do not have that.
Yeah, you would need, you would certainly need, you would need to document the closing of of an account or anything along those lines does not establish that debt has been forgiven. And what you claim by way of your defense here is an important defense. What you claim is that you were forgiven any balances on this. And I don't have any evidence of that. I have evidence that Sandifer had some problems. They were sued, that there was some process that took place. And I believe that the defendant, as a plaintiff in this matter, concedes that there was some changes that were made as it relates to some of the activities of Sandifer. But the real issue here is whether or not you have something demonstrating that the in writing that the indebtedness was that your particular debt was given. Ms. Strickard, you raised in the context of the response to this matter that the defendant received a one moment.
A loan restitution.
It was not a deficiency waiver that was submitted by Mr. Vieke, but you also pointed out that there was some decision to reform the debt, and that there was no indication that he qualified for loan restitution. That he qualified for loan restitution, but not for loan forgiveness. Talk to me about that a bit.
Yes, Judge, and as the court indicated, you're quite right, and we attached at Exhibit 1 the parameters and conditions of the settlement. And as the court can see at Exhibit 1, page 3, Section 2, if you were Section 2, I'm sorry, Section 3, Paragraph 2, the vehicle could not have been.
Yeah, you're kind of cloudy still. I don't know what's your advice today. You're not real clear. But I'm looking at that particular provision. It says the deficiency waiver on that on the page that you referenced. I believe that Mr. Vieke presented this document as well. It says the Sandifer is required to forgive the remaining balance on certain loans. Sandifer will also request that the loans be removed from consumer credit report.
Right, and we have at paragraph 3 of that same page.
I was getting to that only because your advice is not so clear today. I was getting to paragraph 3, which then says for certain consumers, Sandifer sent the consumer title to the car and forgave the balance of the loan. Sandifer did this until the value of the total amount of loan forgiveness across the participating states reached $45 million. Sandifer will also request that the loans be removed from the consumer's credit report. If you're qualified for this, you should have received notice from Sandifer in September 2020. The consumers who qualify for relief, a default on the loan, but the vehicle was not repossessed. All right, so
here it was repossessed.
So counsel, go ahead and talk to me now. I think we have the language of this on the record. Go ahead and talk to me about this.
Yes, the vehicle was repossessed in 2018. So he would not be eligible for a loan forgiveness. He did qualify for loan restitution, and that is the $950 check that he indicates he received in his answer.
I never received it. Never received it, Your Honor. And I never indicated that I received it either in my answer. That is incorrect.
Well, Your Honor,
You
on
could-
paragraph,
Let me stop you. Let me stop you for a moment, Madam Counsel. You said something about a $900 and something check. Tell me what you told me about that, Mr. Diaco.
Pardon me, Your Honor, I couldn't hear you too well.
Well, I see it here. Yeah, I see it here in paragraph 2 of your response. It says the plaintiff's claim is related to an auto loan account opened on March 2018, for which Sandiford forgave the balance of the loan in August 2020 and paid $950 as a final restitution to the defendant. So that sounds like you said that you received $950 from the. That's how that reads. So tell me what you meant by saying.
Yes, Your Honor. What I meant by that was that that amount was paid out, but however, I never received a check or any of that amount. I meant to state like that amount was paid out as far as that 900 and the sum you just stated, it was sent out. However, I never received it. So maybe it was worded incorrectly, but that's exactly how I intended to direct it.
So nobody paid you $950.
None at all.
All right.
I've been getting nothing but them trying to get the money back. I never got a single check from them. And then when I asked them, because I spoke to their customer service, I asked them for documents and receipts of all of this, and they had nothing within their system. This is what I was told when I spoke to them on the phone.
Well, all of that seems to indicate that they have not forgiven the loan. And that's a challenge that you have here, is that they were forgiving loans up to some $45 million. And for whatever reason, yours did not qualify. And that's why you didn't receive forgiveness nor any restitutionary payment.
Your Honor, not to cut you off, I just find that odd because on my credit report, it reflected that both accounts were completely closed and that there was not an amount to be owed on there. I don't know if that has any effect on it, but I just wanted to state that.
Your Honor,
I understood when you told me that the first time. I know that those things they could have some implications, but only after you receive something in writing indicating that that you have been forgiven of this loan. Obviously,
I just lost it, and that's the honest truth, because it had been from so many years ago, and I guess that's on me, but that's what happened.
Your Honor, as to the credit report, Judge, oftentimes once an account is sold, it's reflected as charged off with a zero balance because the entity no longer owns the account. So just because something's showing closed on a credit report does not mean that it is a forgiven situation.
Yeah, I pointed that out much earlier. I mean, the standard of practice in the industry oftentimes results in a loan being closed out and oftentimes not reflective of any indebtedness on the credit report. But that does not mean that the debt has been forgiven. What I pointed out is that if you had a letter or something saying that the loan has been forgiven and you have the credit report, then the credit report has relevance because of the letter that you have. But without a letter, in particular to you saying that Mr. Diaco, we have forgiven this loan, this indebtedness is forgiven. You don't have loan forgiveness. It's illusory unless you got something in writing to that effect. If you don't have anything in writing to that effect, you don't have loan forgiveness. So dealing with the primary issue here, the primary issue is the failure to make the court date. I believe that Mr. Diaco provided a reasonable basis for why he was not here, and that he was attending to something in the nature of an emergency. So that's a showing of good cause, if you will, as to why you were not here for that date. So if that's easy to forgive. I believe in listening to Mr. Diaco talk today, that he tries to be a person that is forthright and honest about his dealings. So if he says that there was something that impeded him from being here at the previous hearing, then I think that there was. The second issue that the statute requires, the court requires, is that you show that there was a meritorious defense. So in order to get the default set aside, and moreover, to proceed with this case what you basically have to show is that there is a meritorious defense, that there is something that can be raised as a defense in this matter that is of such a nature that that the court should set the default aside, or the case should proceed. And the issue that has been raised is the issue that says that the debt has been forgiven. There is no colorable claim to establish that, because there's nothing that's in writing that establishes that in particular to this debt. I took time to take a look at it because actually Sanford reached a settlement and paid out some money, and there were some claims that were resolved by way of forgiveness, restitution, etc. Unfortunately, no, don't interrupt me now. Unfortunately, there's no evidence, nor is Mr. Diacke able to offer any evidence that his particular debt or loan was forgiven. The best that he offers is that his information, his credit report reflects that the account has been closed. The closing of an account is not loan or debt forgiveness. So it doesn't meet the rubric of what would be required to establish before this court that has been forgiven. So there's not a meritorious defense. Mr. Diacke says that he received a letter at some point saying that the loan had been forgiven, but he misplaced it or mislaid the letter. Certainly, if he's able to come up with documentation personal to his indebtedness, then he could bring this motion again, or he could present that, and that would pretty much resolve this case. If he's got something in writing from Sanford establishing that they, in fact, forgave his indebtedness. He just doesn't have that. For that reason, I don't find that there is a meritorious defense to the claim that would be a necessary predicate for setting aside the default judgment. While there is good cause for the defendant not being here, there is not a meritorious defense to the claim that's asserted. And for that reason, I would deny the motion to set aside the default judgment. Stop. Again, I reiterate that to the extent that the defendant can present or come up with a document in particular to this debt saying that it was forgiven, the court will certainly entertain a hearing in that regard, because that would get to the ultimate issue in this case. I saw that you were indicating, Ms. Stricker, you may have to stop now.
Oh, thank you, Your Honor. Shall I prepare an order and email or fax it over to the court?
Yes, that would be a good thing to do. And you're not going to be able to send it to Ms. Latifa because she's away. So send it to Carmen.Banks at 36districtcourt.org. We're right.
And is that CARMEN.BANKS?
That's right.
Okay, thank you, Your Honor. Have a good day.
All right, thank you. All right, thank you. All right, good day to you as well, Mr. Diacke.
Good day.
All right, the court now calls case number case number 22-190352. This is Priscilla Clark versus Mob. That's MABOR Apartments. The matter is before the court on the filing of the motion for summary disposition. Your appearance. Do I have Priscilla Clark on this Zoom? Say something if you're here. Clark is the last name. Do I have counsel for defendant Mark Coleman Properties? It looks like it should be indicated at this time.
Yes, Your Honor, Robert Curtis, and I actually represent all three defendants. I didn't realize when I filed my motion that she had a kind of a faded copy of the complaint. Marcon Properties, Maver Apartments, and Bellcrest Apartments, all three defendants.
Wow. Well, I don't see that in the summons. It looks like the summons mentions a Mavor, that's MAVOR Apartments, Marcon Properties. Okay, now I see 3 Bellcrest Apartments.
Yeah.
All right. So have you spoken with Ms. Clark, today, have you had any contact with her?
I have not, Your Honor. I didn't receive a response. I never received a call. Did send the motion to her by first class mail, and have not heard from her at all.
All right, so I'm looking now, and it looks like the court did send a notice out to Ms. Clark, Preston Point Drive. It looks like it indicates unit number 34. She, in your response, you put 39. Let me see what she had on. Looks like you had 39. That's what she has. So the court notice sent it to apartment 34. I don't know how that happened. And
34, it appears 34, Your Honor, is it looks to me as if she moved. Well, it's either, oh, this is interesting. So either that is in her complaint, that's either a 4 or a 9. I have in some previous notices a 39 documents that the client has given me.
yeah, and the court sent it to 34.
Okay.
Yeah, it looks like it could be a 4 or 9 on the complaint, but that looks like a 9. I think you got it right if you got it wrong. Again, yeah, on the page 2 of the complaint is clearly a 39.
So you do you believe that when the complaint was entered into the system that it was entered in as a 34?
Yeah, because I believe so, because when I look at the notice that set up this hearing date, the notice that I'm looking at now has everything correct, but it has unit 34 instead of 39.
Okay. Well, it sounds like there's a problem of notice. So
Yeah,
what do you recommend we
so-
do?
Yeah, I'm gonna go ahead and set another date because of that, and I'm gonna have the notice sent out. I'm gonna change that to 39 just to make sure that everything is tight.
Okay, Your Honor.
So I'm gonna bring this back. I'm gonna bring it back this month. Just give it a couple of weeks. Let me see. Let's go to the 21st. It's a little bit of a crowded day, but
Your Honor, let me take the 21st is, I think, might be bad for me. Is that's a Monday?
that's a Monday.
Oh, no, that's fine, Your Honor. The 21st is fine.
Okay, 11/21 at 9:45,
Okay.
and we'll get a notice out. We'll get a corrected notice out right away.
Okay.
For that. That way, everything is as tight as it should be.
Okay, Your Honor.
Right.
I will also, just to be safe, send out another copy of the motion to her at the correct address.
Sounds good. And it seems like you got the correct address, but on your motion, you did do unit 39.
Okay.
For some reason, so with 39 seems to be the correct one. So
Okay.
All right, thank you, counsel. Good day to you, and we'll see you on the next action.
All right. Thank you, sir. Bye-bye.
All right, the court calls case number 22-242-881. This is Valerie Dalty versus Unique Tire and Auto Repair. The matter is before the court, set on for a pretrial hearing. Do I have Ms. Daltrey, if you are on this one, say something? I see a symbol there. Do I have someone from Unique Tire and Auto Repair?
Good morning, Your Honor. Lamis Nazal, P84725, appearing on behalf of Unique Tire.
All right, thank you, counsel, and good morning to you. Let me see if I can get Valerie Daltrey. Good morning. Are you there, Ms. Daltrey, Ms. Valeria? If your device is on mute, please go ahead and hit *6, and that should unmute you. All right, Council, I'm going to come back to this, but I appreciate your patience.
Thank you, Your Honor.
All right, this is case number 22-177693. This is always on time transportation versus City of Detroit. The matter is before the court. I think I set this for, well, it's set for pretrial. All right, your appearance for always on time, please.
Good morning, Your Honor. Christina Abro, P78224, on behalf of plaintiff.
Thank you,
Good
Ms.
morning.
Averill. Good morning to you. For defendant City of Detroit, your appearance, Counsel.
Good morning, Your Honor. Alfred Ashew, P82536, on behalf of defendant.
Thank you, Mr. Ashew. Good morning to you. Good to see both of you. Like when we last year, there was some talk about this being consolidated with something that was in circuit court and et cetera. So somebody update, what's the status of this right now?
That is correct, Your Honor. Plaintiff did move to intervene in the circuit court action. That motion was granted. So I'm not sure.
That's correct, Judge. That motion was granted. The reason we haven't sent counsel a stip or dismissed this one is because we filed our intervening complaint and it's still sitting in the queue, so we don't have that back yet. We just wanted to make sure, because we just got the order from the court recently. So I think it was yesterday or something like that. So I just wanted to make sure that we're in that case before we went ahead and dismissed this one. But that should be coming to an end soon.
Well, here's what I would think that I could do with this is simply issue an order dismissing it in light of the intervention in circuit court with a right for reinstatement should something go wrong in that regard. As it seems that the order's been granted, just waiting for things to drop, and that the intent here is that the matter proceed with regard to the circuit court action, and so there's no tricks involved in this. So this would be reinstated if for some reason that falls.
That sounds good, Judge.
That's
I'll
fine.
issue an order. Thank you, Mr. Mr. Ashew. I'll issue an order in that regard. You get it from the next few days.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good day to the two.
You as well.
Ms. Autry, if you are there, I'm going to send a chat.
Your Honor, I did send her a direct message as well.
I'm sorry, what did you say, Counsel?
I did send her a message as well.
Okay, perfect. Looks like she
I think she dropped.
dropped, and then likely means she'll fall back in. some more sticking to it. All right, good morning to you, Ms. Daltrey, are you there? I think if you press *6, that'll get you off of mute. So you should have on your device something, a symbol like a microphone. You need to tap that so that you can unmute yourself.
Hello,
Hello, good morning. Who am I speaking with?
good morning. I am so sorry. I've been trying to get on and it's not letting me get on. I don't know what happened. It won't let me hit mute or turn it on. So I'm very sorry.
That's all right. What is your name?
My name is Valeria Doty.
All right, you are on now, all right? I guess you're using your phone, are you?
Yes, sir.
All right, good enough. All right, so I've called the case regarding Daltrey versus Unique Tire and Auto Repair. And counsel, Ms. Nazel has entered her appearance regarding this matter. I see that in this case, you are requesting that awarded damages. Looks like in the amount of $6,500. What is this? This has something to do with car repairs or something?
Okay, what had happened, I had an engine put in my car. And when I took it there, I had asked them to put it on a diagnostic machine to make sure that they find out what exactly is wrong with it. So when he called me, he said it was the engine. And I told him that I don't think it was the engine. And I said, could you please check it and make sure that it's not the engine before you do any work? So he said he checked it, and I asked him about 3 different times if he could check it and make sure he put it on a diagnostic machine. I asked him, did he put it on there? He said no, that he put it on a different machine, and that I forgot what the name of the machine he said he put it on. But whatever the case may be, when he did the work on the car, I had came up there that week. And after I got up there, like a couple of days later, he called me and said the engine was in. When I got there, it wasn't in, but about 2 or 3 days later, he called me and said the engine was in and that I could come pick up the car. So he said that something was wrong with the battery. And so I said, well, my battery is fairly new, shouldn't be nothing wrong with the battery. He said, well, that's what, the battery, something was wrong with the battery. So when I went to pick it up, I paid him all the money. And when he said, well, I asked him if he could come and take me to see the car. So when he started it up, the car wouldn't start at first. And so then I said, well, it shouldn't be nothing wrong with the battery, but he started it up again and the engine was shaking. And I said, why is the engine shaking? He said, I don't know, it's probably the battery. So I ended up calling AAA to have them to come out, and they said nothing was wrong with the battery. So, I had told him, I said, well, I need you to fix my car because I paid you $2,700 to fix it. And so it was getting time for them to close. I took the car home, and he told me, you got 6 months, parts and labor to bring it back. When I went to take it back, he started saying it was 2 different other things that was wrong with it. And so I told him, I said, I don't care what it is, fix my car. So he didn't want to fix it. What the boss man said that they would fix it. But when I went to go up to try to fix it, the guy told me that because I called the police on them that they wasn't gonna fix it and then bring it to court, and so that's what I did.
All right. So, we're not really into the trial. I just want to get a general sense of what's going on here. So what type of car did you take to the shop? What was it?
It's a PT Cruiser. I sent in all the pictures and everything. It was a 2007. Sorry.
Oh, 2007 PT Cruiser, is that correct now?
Yes, sir.
All right, you're not a mechanic, correct, Drew?
No, I'm not. But I do know a little bit about cars. I'm, you know,
I didn't
I
ask you that.
can't million.
I didn't ask you that. It would help you, answer my question. If we have a trial on this, you get a chance to go into more detail. I just kind of want to get a general sense of it. So, my questions are closed in for a particular reason, So, we all know something about cars, right?
Yes.
What was going on with your car when you took it in? What problems were you having? What did you see that was wrong?
Well, what had happened, I had drove it to one of my daughter's house, and it was running real good. Wasn't no problems with it when I, drove it over there. But when I went to get back in, the car wouldn't start. I did have a mechanic to come and look at it, but he wasn't really able to do much because, that day his wife was going into the hospital.
Okay,
But
so
he did say that.
Let me stop.
Mhm.
Let me stop. The reason that you took the car to Unique was because the car wouldn't start. Is that what it was?
Yes.
All right, Council. Well, let me ask you one other question, ma'am. Did you ultimately get the car repaired to the place where it was working?
I'm sorry.
Did you ultimately get your vehicle repaired, get it back to operation?
No, once I told it to them, I let them fix it.
Okay, so you took it back to, who did you let fix it? That's what I'm saying, ultimately.
I can't hardly hear you. I'm sorry.
Yeah, did you ultimately fix the car? You said you took it back to them. What happened? What was the end result?
No.
Did the car-
So once I left it there and he said that they wouldn't fix it, I had left it sitting for a while, but I was gonna take it to a friend to see if they, could do it, if they could do some work on it or find out what was wrong with it. But when I took it, they said they wasn't able to do anything to it. So I was driving it back home when it caught on fire.
Also, you never got it fixed. You never got it totally fixed, correct?
No, sir, I didn't.
All right. So you said it caught on fire and the car is totally destroyed. Is that what happened?
Yes, sir.
Okay. How long after you took it from the shop did it catch on fire? How long after that?
I think it was about maybe a month because I had it sitting for about maybe a month or so.
And so you drove away from there, and then a month later is when it caught on fire.
Oh, no. When I drove it from them the first time, I took it back up there and, just, cause he said, bring it back that Monday. I took it back up there. That's when he said, well, it's an O2 sensor and it was something else. And I said, well, I don't care what it is, just fix it. I knew it wasn't neither one of them problems because his engine was shaking.
Okay,
And he didn't.
Let me stop you because you go on and on and on. I don't need you to do that right now. Here's my question to you. And my question has to do with what ultimately happened. You told me about all of that already, okay? And at some point, you said you picked the car up the last time. You picked it up. I want to know what happened to it when you picked it up. Did you get it repaired? What happened? Are you saying that the last time you picked it up when you were driving away, it caught on fire?
No, I didn't caught on fire right away. I drove it home and I had it sitting for a while. So I was going to take it, I had it, but it was smoke. It had started smoking. So I had it sitting until I was able to get somebody to fix it.
Did you get anybody else to fix it? Did anybody else work on the car after you took it from?
No, sir.
All right, thank you. All right, so council, yes, where's your client coming down on this? Is there some room to talk to see if there may be a way to get this resolved? Go ahead.
Yes, Your Honor. Just briefly, my client has a reputable mechanic shop in Detroit. He's serviced thousands of vehicles before. Unfortunately, in this situation, he's indicated to Ms. Daughtry that there is work that needs to be done more than what Ms. If I mispronounced her name, I'm so sorry. Doughty. Is it Doughty? Okay. that there was more work than what she anticipated needs to be done. She indicated her reluctance. She took the vehicle out of the she took the vehicle a month later. It caught on fire. My client did what he could to repair the vehicle to, to the best of, to what he could. And at this time, he's disputing that he owes Ms. Dottie any money. I believe he did attempt to reach out to her to reimburse her a portion of the money she did pay, just so due to client satisfaction, he didn't want her to walk away unhappy. But unfortunately, it didn't go well. So at this time, I don't have any of the documents or pictures that Ms. Dottie is indicating she has in her possession. So I would just ask for some discovery so she could send them to me. I could take a look at them. I could talk to my client about it, and maybe we could try to work something out.
All right. Yeah, that sounds like a reasonable path forward. Here's what it sounds like to me. I haven't heard the case yet. I'll take testimony if it comes to that point, and then I'll weigh both sides and then determine what the outcome of the matter is. It sounds like to me that, at least on the face, it sounds like to me that the mechanic did not give the full breadth of diagnosis as to what it would take for the vehicle to be brought to a state of full operation when the vehicle was brought in. Therefore, you have one effort to repair the vehicle, and then the client comes in to pick it up and has problems, and you have a whole list of other things that you've done. Those things seem to have been some issues that probably should have been noted as possible items requiring repair. So you don't know if the replacement of the engine triggered other kinds of issues that would occur. So it starts to sound like to me, and that your client reaching out to her was probably reasonable. And
can I please say something?
Did you hear me? Did you hear me talking?
Your Honor, I didn't hear anything that you said, maybe the last two sentences. I wanted to interrupt you, but I didn't want to be rude.
Okay. I don't know what's going on with our system. All right, is everybody able to hear me now?
Yes, that's not true what you're saying, Ilana. And God knows she's telling a story, and they are too. They're not telling the truth.
Your Honor, as an officer of the court, just to make the record very clear, this is what my client has indicated to me. I wasn't there. I wasn't present during the circumstances.
Of course. And it's easy to start talking about people lying and so on and so forth. And people unfortunately do tell lies, but that's the information that the attorney is indicating that she received from her client. But we're past all of that. We're past all of that. The issue is here that it is probably a reasonable thing to have done if that was what was done, because this does seem to be a case that where nobody got satisfaction here. Ms. Daltrey took the vehicle into a reputable repair shop, and they put forth an effort to repair it. They got it wrong. That's what it sounds like. Even though they put forth perhaps what they received to be their best effort, they got it wrong, and it left the car in a worse position than what the vehicle was in at the time that she brought it in. That's what it sounds like happened. And the best of shops, the best of clients bringing vehicles in, that's the nature of things that happen, particularly when there is a shop that deals with vehicles that are as old as this vehicle is, and that does a job that's as major as placing an engine in. So there doesn't have to be bad actors here. Maybe there was. There don't have to be bad actors here. This is a situation where there's substantial risk taken by both sides. You have an older vehicle, and you have a major repair that's done, and that results in the outcome that we're seeing here. So I can't tell the parties exactly what to do. I do that through issuing rulings in the context of a hearing. But it sounds like to me that this is a situation that should be resolved by the reimbursement of the cost of repairs that was paid out in this matter. it probably is something that should be settled in the nature of about $3,000 or so. You all can talk about that and try to get that resolved. I think that's the most reasonable way of doing it. It's going to be difficult. It's going to be difficult to establish damages beyond that because of the age of the vehicle. And because the vehicle was in a state of disrepair when the vehicle was brought into the facility. But it does seem that Ms. Daughtry has been damaged here and that it should be resolved. If the parties can't resolve it, I'll listen to everything on the trial date and weigh all sides of it and get to hear from the repair persons, et cetera, et cetera. I'm willing to listen to all of that. But in my almost 40 years of doing this, 30 years as a judge, that's my take on it, just hearing stuff facial, right? So I can set this up and the parties can spend some time doing discovery for exchanging information, or you could start out by talking in the breakout room to see if there's a number that will settle. Because obviously this has been going on for a little bit of time, so you get some kind of settlement to move on from here, and it probably makes sense rather than the court setting it up for discovery. That would give it another 60 days. The next hearing would probably end up being in January, and then after that, the court will see what the case is, and then we'll set a trial date. So we're probably looking at either February or March before we really get into having a hearing on this. And that's why I took time to kind of listen to a little bit today, just to get a kind of sense of the case. I'm not on one side or the other of this. I'm not, I just want the parties to be able to hear my thoughts about it, just hearing stuff on the surface. I haven't looked at pictures. I haven't looked at, I haven't spoke to repair persons. I haven't talked to the person that did the diagnosis to determine what should be done. But this is, but just what I've heard says that something went wrong. And because something went wrong here, that a refund, and probably a little bit over what the amount was that was paid in this matter, should be the resolution in this case. But 6,500, you're never going to be able to get there unless there's something real extraordinary that I'm able to see in this case, primarily because of the age of the vehicle. So you got my sense about it just a little bit. If you want to take a moment to talk in the breakout room and kind of see if you can get to any resolution here.
Your Honor, I don't have, my client isn't present, readily available for me to discuss a settlement with him, and I don't have authority at this moment. I took down Ms. Dottie's number to, if I may, just to confirm, it's the number that appears on the Zoom gallery, if that's correct. I can go ahead and give her a call after I have a chance to speak to my client. But if the court will allow, I could submit an order for discovery. So this way, Ms. Dottie can submit to me the evidence that she has, and I can review it with my client.
All right. So Ms. Daughtry, what I'm going to do is the court's going to issue a scheduling order, and I'm going to send it out to the parties. It will allow for the parties to have a period of discovery. And anytime during that process, the parties can resolve this. I just gave the parties some indication of where that resolution should be. And if the parties reach out, if the plaintiff reach out to you, or sorry, that the defendant reaches out to you, then take some time to talk about it. Talking about it, maybe you have to resolve it, but talking about it is the only way that you're going to be able to resolve it. If you talk about it, you can find a way to a resolution. Good. If not, I'm beginning the process of setting it up in such a way where ultimately you end up in trial and you make a decision. Yeah, there you go. You have to turn one of your devices off, otherwise it will make that kind of sound. So, all right. So the next date in this matter is going to be. So I'm setting up discovery. The next date in this matter. Let me try to get you. Well, I won't be here then. All right. January 3rd. January 3rd will be the return date in this matter. That's going to be a pretrial conference date. The order that I'm going to grant is going to allow discovery through that date, meaning that both parties can exchange information. If there's anything that either party has that you want, all you have to do is put something in writing and say, I want. This process can involve interrogatory, which is a set of questions that would have to be answered. It can also involve requests to admit statements that require that you admit one way or the other as to the truth of it. And either party, both sides can exchange such information over that period of time. When you come back on the 3rd, there will also be a motion hearing date, meaning that if either party has filed a motion or petition before the court, I will hear it on that date, as long as you file your motion at least 10 days before the hearing, giving the other side at least 10 days to respond. So if you file a motion at least 10 days before the hearing, give notice to the other side, and I will hear your motion on the 3rd of January. So that hearing is going to be January the 3rd at 9:30 a.m. will be the next action date in this matter, and you will receive an order of discovery from the scheduling board that has the discovery that I mentioned, allowing through January 3rd. Right? All right. I wish both sides well. And keep talking. Maybe you can find a way to resolve it, get it resolved. And all you need to do is submit an order, and the court will sign off on it in case we can resolve it.
Your Honor, I appreciate that.
All right, thank you.
Thank you, Ms. Elvin. Good
Have a
day to
nice
you. Right. Thank you, court reporter. Thank you, ma'am.
Hi,
Good day to you.
how are you?
I'm good. I'm good. All is well.
Yes, all is well.
Perfect, perfect. Thank you for being here and helping us get this done today.
Oh, you're welcome. No problem. Enjoy your afternoon.
Likewise to you.
All right, take it easy, Frida.
Okay, see you, Miss Banks.
See you later.
Bye-bye.